Hi, folks. Welcome to today's webinar from Bob Benny Wealth Management. I'm Bob. This is Jesse Thompson, my daughter Jessie, and we're glad that you're all attending the webinar. This is the biggest attendance webinar we've had so far by a long shot. So the topic obviously is very important to you, and it is to me. It's a critical topic, and it's how to efficiently transfer wealth. I'm calling it estate planning 101. And go ahead.
So there is a question feature down at the bottom of your screen. If you think of any questions while we're talking, it looks like a little like comic chat box. And so just click that. You don't have to put your name if you want your question to be anonymous, and we won't say your name.
We won't say their names even if they have their names on there.
Right. We won't say your name either way. And just a reminder that nobody can see you guys on this either. So, yeah.
But we're going to answer the chat questions at the end.
Yes. Yep.
But if you think of something as you're going along, please chat away.
Yep.
This is going to last about 30 minutes, maybe a little bit more, maybe a little bit less. We practiced it earlier and it was a little bit less, but I might get kind of windy. Who knows? I could go on and on. You might be here for a couple hours. Hopefully not.
So the first thing that we're going to do is start out with some quick facts about estate planning. So only 58% of American baby boomers, and they're classifying this as people ages 53 to 71, have estate planning documents. Now, this is any estate planning document. So they might have a will or a power of attorney or a trust. It doesn't mean they have a full estate plan. It just means they have some sort of estate planning document. 64% of American adults who work with a financial advisor have never talked about their estate plan with their financial advisor. 35% of American adults say that they've personally experienced conflict in their family or know someone who has as a result of not having estate plan or will in place at the time of passing. The probate process can cost up to 10% of an estate. I think the average is 5 to 8%, but it can get as expensive as 10%, which is huge.
And it's unnecessary.
And it's unnecessary, which we'll talk about. And then also it can take anywhere from several months to over a year or years, depending on how complicated it is to probate a will. So going off of those statistics, the statistic about 58% of American boomers having some kind of estate planning document in place, I would assume probably for most people that's probably a will. And I think the assumption is that most people think a will is enough to efficiently transfer their assets to their heirs at the time of their passing. Can you explain why that's not true?
A will is not efficient at all. A will is just a letter to the probate court. And if you have a will and the will's being read and being used, you're in probate. We want to try to avoid probate. Probate is expensive and takes a lot of time. The way things end up in probate is if a dead person's name is on the title of an asset, whether that asset is an account, a bank account, an investment account, or a car or a house or an airplane or a boat or any kind of a titled asset. Think about it. If Bob Benny owns a house and Bob Benny dies, nobody can do anything with that house. It's frozen until it goes through the probate process. In the probate process, a will says that my house goes to my wife first, in our case. And if she's not around, your spouse, that it's going to go to you kids. We have 4 kids. Jesse's one of them. If I didn't have a will, the state of Nebraska says that's how it goes anyway. So most wills are useless from the standpoint of designated beneficiaries because they designate the spouse and then the kids. Well, that's going to happen even if you don't have a will. I'll tell you why you have a will, in my opinion. It's to benefit the attorney that drafted the will, because he gave you this will and then he or she put it in an envelope that's got the attorney's name on it. And almost 100% of the time when the kids find that will, they're going to call that attorney to probate the estate. And that's where the attorney makes the money. He doesn't make money from charging you $200 or $250 to draft a will. He makes a significant amount of money from taking your estate through the unnecessary, in my opinion, probate process.
The other question that I had based on those statistics or thing that I wanted to talk about was that 60% of people who work with a financial advisor have never discussed their estate plan with their financial advisor. Here we make a big deal out of estate planning, and that's a main part of our process and very important. Can you explain why that is and how you got into estate planning?
Well, I started helping people with their estate plans, and particularly revocable living trusts, over 20 years ago, I think 22 years ago. And it's an ancillary service. We don't make any money on it, but it's part of helping take care of our clients' wealth. It's Bob Benny Wealth Management. And of course, we do investment management for them. We help them with figuring out tax strategies and retirement income planning and estate planning. Well, the way that it came about was I had a client, I won't say his whole name, but I remember his name was Richard. Richard had a lot of money, and I thought because of potential federal estate taxes, that he should get a trust. So I sent him to an attorney that I trusted to help him, and Richard went to the attorney, came back a month or two later, kind of threw the trust down on my desk, kind of ticked off acting because he didn't understand the document. And he said, "Is this what you wanted me to get?" So I started reading it, and in the trust, they named as successor trustee, and the successor trustee is the person that you name to manage and distribute your assets after you, or in his case, he was married, after he and his wife were both deceased. And the successor trustee that they named was a financial institution, a trust company. And a trust company, they're not going to do that for free. Not only are they going to take control of all of the assets, the investment accounts, the house, the cars, they're going to take control of all that stuff, but they're also going to charge to manage it and charge to distribute it to Richard's kids. So I see that and I'm alarmed. And I said, "Well, Richard, what's the deal? Don't you have 3 kids?" I knew that he had 3 kids, and I knew that they were okay. I said, "Is there something wrong with the competency or the capacity of your children?" And he said, "No." And I said, "Why'd you name this trust company as the successor trustee?" And he says, "I don't know. I didn't do that. The lawyer put that in there." And so at that time, I figured out, I can't be referring our clients to people that set this up that in a way that's going to waste money unnecessarily on lawyer fees or on trust company fees or whatnot. And so I started learning a lot about estate planning 3 years ago. One of the things I did was I went to the county courthouse, to the probate court, and anybody, me, you, any of our clients, prospects, anybody watching, you can go to the county courthouse and go to the probate court, and you can ask them to see the file of any estate that's been probated. I went in there and I just simply said, "Can I have the last," I can't remember whether it was 6 or 10, the last 10 completed probate cases in Lancaster County. And they said, "Sure you can." Set me over in a cubicle with a little desk. And 5 minutes later, they came over with these, whatever, 6 or 10 files, thick files, manila folder files. And I started perusing through them. It's totally legal. And anybody can do it with your estate if you go through probate. And there's one that particularly struck me, because you read enough of the documents, you figure out what the deal was. This guy was an old man in a nursing home situation, didn't have any real estate, didn't have a car. All he had was his clothes and whatever furniture. He had $1 million. He did not have a spouse or any children. And God bless him, he wanted to leave that $1 million when he died to 5 different charities. And so he went to an estate planning attorney. And the estate planning attorney wrote him a will and a testamentary trust, not a revocable living trust. And nothing got put in the trust until the old man died. And so the way that it worked out, because you can see all the financial stuff. So really, like I said, he had $1 million. He wanted to give it to 5 charities. That's $200,000 per charity. Well, so none of his assets were retitled. They were in his name. So they had to go through the probate process when the guy died. And by the way, he'd gone to a estate planning attorney to do this. And so his $1 million in 5 accounts went through the probate process. And then those accounts got probated into his trust that the lawyer had written. The lawyer, same lawyer that wrote the estate plan, probated the estate and charged his estate $50,000 to do that unnecessarily. Because if he'd had a revocable living trust and retitled the assets prior to death into the name of the trust, they wouldn't have had to go through probate. In addition to that, the lawyer had named a financial institution as the successor trustee. All they had to do was cash in the accounts and write 5 checks to 5 charities. They charged $500 or $50,000 also. So, he didn't have to do that. He could have had a revocable living trust, had stuff titled in the name of the trust so it didn't go through probate. He could have asked one of the charities to have their treasurer do the same thing that the trust company did, which was just liquidate the assets and write 5 checks. They would have been glad to do that because they're a beneficiary of $200,000 anyway. And yet, so what ended up happening though, instead of giving $1 million to 5 charities, he gave $900,000 to 5 charities and $50,000 to an attorney and $50,000 to a financial institution trust company unnecessarily. And so we have developed a process of helping people create their own revocable living trusts. I'm not a lawyer, but I know a lot about this. And there are lawyers involved in the process, but you sit with me and I help you develop your own estate plan, set up your own revocable living trust and all the ancillary documents.
So let's talk about what a living trust is.
So a revocable living trust avoids probate if it's funded, meaning if the assets are titled in the name of the trust, they don't go through probate. The way something ends up in probate is if a dead person's name is on the asset. Think about it. If Bob Benny owns a truck, which I do, and I die and my name's on the title of that truck, nobody can sell my truck. My wife can't sell it. My kids can't sell it. Doesn't matter if I have it in writing, whatever, my name's on it. It has to go through the probate process, and either with my will that I say that somebody gets the truck, or the Nebraska intestate succession, which says my wife gets it, then the kids get it if she's not around. That is frozen and has to go through probate and have to pay lawyer fees and the time. So living trusts avoid the assets, avoid probate and the expense of time of probate as long as they're titled that way. Speeds up estate settlement. We had 3 clients die this winter in the period of about a month and a half. They've been longtime clients. We've managed their money, done revocable living trusts and estate plans for them. All of their trusts were settled within a month or 2 of the death of the client. Living trusts keep matters private out of the courthouse because you're not in probate. somebody can't go in to the courthouse and see all your information and all your business like they can, like they did with that old man I told you about that had the $1 million left at the 5 charities and got screwed out of 50,000 a piece from a trust company and a law firm. If necessary, it preserves both. A living trust can preserve both federal and state tax exemptions, but we're not worried about that right now because of the current laws. But basically, trusts save time and money. You didn't accumulate whatever wealth you have through earning and saving and investing in order to make a law firm a 5 to 8 to 10% beneficiary of your estate.
So as far as keeping things private, so if something goes through probate, it becomes public information. One of those statistics that we had talked about earlier was that a great amount of people have experienced family conflict due to there not being an estate plan and trust in a estate plan in place at the time of death of one of their loved ones or know somebody who has. Can you explain how a living trust kind of keeps things private even within a family, or could maybe help to avoid that kind of conflict?
Well, first off, if you don't have a trust and it's a will, there's a probate hearing and there's probate, and wills can and are contested sometimes. So a trust, it's not in probate where anybody can contest it. However, there can be conflicts. People are people. Families sometimes have conflicts at the death of someone. But the basic fact is the successor trustee named by the creators of the trust, mom and dad or whatever, the successor trustee is the person that they named to manage and distribute the estate according to their instructions. And so the successor trustee is really a dictator. He's totally in control of the assets, just like the trustor, the creator of the trust, was in the first place. Something that people can do ahead of time is tell the family that we created this trust. You guys are the beneficiaries of the trust. We've named so and so, maybe the oldest son, maybe the son who's really good with finances, or maybe they name the daughter the successor trustee for whatever reason, and I can help them figure that out. They name somebody as a successor trustee because they trust them and they're competent to do this. We named Sally to be the successor trustee, and Sally is going to handle all this, and we trust Sally and we want you to trust Sally to take care of it. That's a way that it can be done, and they can't contest it in probate. If they wanted to file a lawsuit, sometimes trusts are even written so that there's a clause in there that if anybody tries to sue the trust, any beneficiary tries to sue the trust, they're automatically disinherited, and that'll sure stop them if necessary.
So let's move on and talk about how a living trust works.
Okay. So I'm using this, what it says up there, husband and wife. They're in trust lingo, that's called trustors. They're the creators of the trust. They create this trust. They get it all gets written up. Basically kind of how you think a will is written up, where it says that these are the beneficiaries and these percentages are in these amounts, and we want to give a certain amount to charity or whatever it is you want to do with your assets. How, when, and how much you're going to give the beneficiaries. You name in there a successor trustee and an alternate, like you would name an executor of a will. But instead, this is called a revocable living trust. To get things into the trust, they have to be retitled. So we retitle the house, the cars, the financial accounts, the airplane, the boat, anything that's titled, it's retitled in the name of the trust. The husband and wife are also the trustees or the manager. That's kind of what trustee means. They're the manager of their own trust and the beneficiaries of their trust, as long as either one of them are alive. If one of the two passes away, the other one is still the trustee and is still the beneficiary. Nothing happens. They lose no control whatsoever over their stuff until they're both dead. There's also in there the ability to resign if they want their successor trustee to take over stuff, and that happens sometimes. To resign as they get older and less feeling like handling stuff. Sometimes they'll write a letter of resignation, and if they somehow get Alzheimer's or something like that, or are named incompetent, they can, that can make the successor trustee the manager too. But then after both mom and dad are gone, the successor trustee distributes the assets to however they have it written, in whatever manner they have it written in the trust, just like a will would. Typically, people leave assets, if you have, in our trust, it says we have 4 children, they get 25% apiece. But that's basically how it works. Does that answer your question? Hope so.
So the essential parts of a comprehensive estate plan, what we talked about earlier is that around 50 to 60% of people of the baby boomer age have some part of an estate plan, but probably not a comprehensive estate plan. So these are the essential parts.
If I can interrupt, not very low percentage have everything they need.
So they might just have one of these, like we talked about earlier, most likely probably a will or a power of attorney. Right. So the essential parts that you need in every estate plan, and you need every part, is a revocable living trust that we talked about just previously, power of attorney for finances. If you're deemed incapable, and you have to be deemed incapable by a doctor in order, or you have to voluntarily give this power of attorney over.
And if I can interject something, a power of attorney for finances or a power of attorney for assets, power of attorneys apply while you're still alive. And they apply to assets not inside your trust. So your trust, if you're incapacitated, your successor trustee manages those things in your trust for you while you're still alive. But some things are can't be in your trust, like your IRA. The purpose of the power of attorney for assets applies to your IRA, which is not inside your trust, and you get Alzheimer's or you're real sick or whatever. That allows that person, usually it's the same person that you named as a successor trustee, but this is what that's for. Go ahead.
Okay, and then the next one would be your power of attorney for healthcare, or an advanced care directive. If something happens to you and you can't make decisions on your health for yourself anymore. Next is the proper titling of assets and beneficiary designation. So like we talked about earlier, in order for something to be in your trust, you have to title it in the name of your trust, your home, your cars, things like that. And then as far as beneficiary designations go, things like IRAs cannot be in your trust. So you have to make sure that you have up-to-date beneficiary designations on all those. And then lastly is a pour over will. And this is for anything that might have gotten missed, that you might have forgotten to put or title in the name of your trust. And this is just in case type of letter to the probate court saying, I meant to put this in my trust. If it happens to go to probate, that's where it should go in my trust, basically.
Right.
So we're going to open it up to questions now. If you guys want to type in any questions that you might have, it doesn't look like we've gotten any so far, but we're going to give you guys a couple minutes and kind of explain the process of how we can help you with estate planning.
When I first started doing this 20 some years ago for our clients, Jesse, I did it through a national company called the Estate Plan. It cost, depending on the situation, $2,000 to $2,500. That was split 3 ways, not evenly, but 3 ways between this company called the Estate Plan, an attorney that kind of rubber stamped it, and me. I got the short end of the short third of it, let's say. But some years ago, I ran across, I researched another company that y'all are familiar with called LegalZoom. They advertise on TV and on the radio, where you can make your own estate planning and other legal documents through LegalZoom. I tested one. The documents came back and they're just as good as the other documents we were paying a lot of money for, but at a much lower cost. The way the cost is for all those documents that you need, the revocable living trust, the powers of attorney for healthcare, the powers of attorney for assets, the pour over will, everything that we talked about. The all-in cost for LegalZoom is about $450. We don't get any of that. We don't charge for any of this. I don't charge for any of it, never have. And in lieu of paying me, we ask that our clients make a voluntary contribution to my favorite charity that I've talked to a lot of them about, called Royal Family Kids Camp. It's a camp for neglected and abused children. They're summer camps. They have a few hundred of them go on every year. They have about a dozen in Nebraska. I've gone and helped. It's a week-long summer camp, and I've gone and helped at the camps for a week every year for the last, whatever, 9 years or something. But it's really an awesome program, Royal Family Kids Camp. Ask that people make it. We don't require that they make a contribution. Sometimes we forget to ask them. Sometimes we forget to remind them. They will make contributions, if they do, anywhere from 100 to, I've had a couple of clients make contributions for $1,000, and that's all welcome, whatever. But it's only $450 for the cost of setting up all these documents. There's 3 steps to it. You come in my office. There's 3 appointments. The first appointment is creating the trust. When you come in my office, we pull up LegalZoom on my big screen. It starts going through and asking questions, and you can do this yourself. It's just you've never done it before, and I've done it hundreds of times, and I can help you answer the questions for distributing and allocating to who, and who are you going to name as power of attorney for healthcare, and who should you name as power of attorney for assets, and particularly who are you going to name as successor trustee and alternates. And we enter all that stuff in. At that time, you also pay. You pay LegalZoom, you enter your credit card in, pay and set that up. So then in a couple of weeks, then we have the second appointment, because LegalZoom has produced all these documents. They've sent them to us. We've gone through them, make sure they're right and all that stuff. And we call you in and we have the second appointment. The second appointment is, I call it a signing powwow. It's the execution step. So the first step in trust lingo is the creation step. The second step is execution, what I call the signing powwow. So we sign, witness, and notarize all of your documents with you, and re-explain what each of them do. We scan all the documents and provide you with a photocopy of all the documents in a separate envelope, separate from the 3-ring binder that's all tabbed off and organized that you get the original document in. And besides giving you a copy, we also scan also a scanned copy of that is what I'm trying to say. And a digital copy goes in your personal financial website that you have if you're a client of Bob Benny Wealth Management, so that you can access and see that anywhere in the world that you have internet access. So creation, execution, and then the third step is funding. And the funding is critically important to avoid probate. It doesn't do any good to set up a living trust if you don't have stuff retitled in the name of the trust. So we help you and tell you how to, and encourage you, everything we can do to get everything funded. So that's your house. House needs to be retitled. Your automobiles need to be retitled, and all of your financial accounts that are non-IRA accounts need to be retitled. If you have a life insurance policy, we can tell you how to change the beneficiary of the life insurance policy to the revocable living trust, because that's a better beneficiary usually than how you have it set up. In addition, we help for free with no charge. We help clients and their families, that is, settle their trusts after they pass away. Like I mentioned before, this winter we had a few clients pass away in a short period of time. All of their estates were settled within a month or two by the successor trustee, which was a family member, and we assisted them doing that at no charge. It's not hard. You don't need a lawyer to create a trust. You don't need a lawyer to settle your trust. And that's where you save the money and the time.
So let's check and see.
Okay.
We do
Okay,
have, we have one question.
Go ahead and read it.
This is somebody who has a trust, but they say they're concerned that if I and my spouse become incapable to be left alone and need to be in a home, how can we protect our assets from the government in this situation?
The trust does not protect your assets from paying for your nursing home care or long-term care if you end up in a long-term care situation. The trust, the only way to avoid paying for your own nursing home with your own assets is to give those assets away long before you go into the nursing home. And I don't recommend that. I think it's a 5-year look back period that Medicaid looks at before they'll start paying for long-term care. This particular client that we're talking about has enough assets that that's not anything he needs to worry about. There's going to be enough assets to pay for if both of them go in a nursing home to comfortably take care of them without dipping into too much of the principal of their investments. And so, but the trust does not protect assets from nursing homes or Medicaid. It's not the nursing home, it's the government makes you pay for your health care until you run out of money. When you run out of money, then they'll pay for it. That's the deal. But anyway, thank you for that question. Do we have any more?
I have one kind of a little bit piggybacking on that question. Speaking of giving away assets while you're still alive, for people who are thinking that they would like to maybe give their assets or some of their assets to their heirs before they die, what advice would you give them in that situation?
I would advise them to talk to me about what assets it's okay to give away before you die and what assets it might not be too good of an idea. For instance, you see this thing happen more often than it should, is somebody will give what's called a capital asset that, like for instance, a piece of real estate like a farm. They'll consider giving that farm to the kids before they die. Well, what happens then is the kids, the person you gift the asset to, they get your cost basis on the asset. And when if and when they eventually sell it, they got to pay capital gains taxes on it. So let's say, for instance, that you have a farm and you paid $50,000 for the farm, and now the farm is worth $500,000. If it's left in your estate, in your trust, or even if you didn't have a trust, if it ends up going to if you still own it at death, your beneficiaries get a stepped up cost basis. Their cost basis for that asset is the value on the date of your death. So in my example of a farm that Dad bought a long time ago, only paid $50,000, and now it's worth $500,000. If he sold it before he died, he'd have to pay capital gains taxes at 20% on $450,000 worth of gain. But if he left it in his estate and the kids inherit it, or the beneficiary inherits it, the capital gains, according to current law, the capital gain or the cost basis is stepped up to the value on the date of death. And so if the kids turn around the day after he dies and sells the farm for $500,000, they don't have to pay any tax. If they sell it for $600,000 a year later, they only have to pay the gain from 500 to 600, not the whole gain from what he paid for it. So that's the kind of thing that you got to, take into consideration, is the possible tax consequences. It's not a gift tax consequence, but it's possible capital gains tax consequences of gifting away an asset that nobody would have had to pay taxes on if you just left it in your estate.
And that would apply to investment accounts, non-retirement investment accounts.
Yeah,
Same
it would
exact.
apply, same thing,
Okay.
same example I said, if it was a $50,000 stock that had grown to $500,000, rather than selling it and giving the money to the kids prior to death and paying taxes on the gain, or rather than just transferring the asset to the kids, better yet would be just leave it in your estate so that the cost basis is stepped up on death. And so there's a lot of ins and outs to this. And, and appreciate the question though. That's a great question.
Let's
We got
answer
another
this
question.
one other question. This is somebody asking if we can, they have a trust already, asking if we can analyze a trust. Anybody that already has a trust that wants you to look at it, we'd be happy, more than happy.
Yeah,
to
we
look
can
at
make
it.
sure that everything is in place the way it ought to be, help you make sure that everything is titled the way that it ought to be. This guy also asked about that. He asked if he could retitle the stock in his business as it's currently in his name. Of course. Yes. You know, I have two businesses, three businesses actually. I call my acreage a farm, so that's kind of a business. But I have Bob Benny Wealth Management that you all deal with. That's called an S corporation. My wife and I are the owners of the S corporation, but some time ago we changed ownership of the company to the trust, so that when something happens to the two of us, that corporation, that entity doesn't go through the probate process. We also have a thing called an LLC, which is very similar to an S corporation that owns the building that Bob Benny Wealth Management is in. And the ownership of the LLC is the Benny Family Trust that your mom and I are the trustees of. So absolutely, you can change ownership of your portion of pretty much anything into the name of your revocable living trust, and we can help you. You know, we would welcome any more questions that anybody has. You can email us or call us, and we hope this has been helpful for you. If you have family or friends that might be interested in this information, we're going to have the video available, or they can call or email us, and we can send them a link to the video, or we'll have it at some point on the website that they can get to.
Put them all on the website and all on YouTube. So
yeah, so we're kind of trying to be YouTube stars with these videos, but we thank you all for attending. Is there anything else we need? Oh yeah, go ahead. Tell them about the next.
Our next webinar is going to be September 15th at noon, and that one's going to be on the essential things for retirement income planning. If that's something that you're interested in, we're going to send a mass email out just like we did to invite you guys to this one, and it'll also be on the website. So
and we encourage you to think about friends or family members that might be interested in this information. These webinars, we try to keep them pretty short, like a half an hour. This one, I guess, is 38-minute long because I got kind of windy telling my stories, but and answering questions. But we will, of course, welcome your friends and family to be involved in it. They can either watch it with you, or if you want to have them call us, or you call us and give us their email address, we'll send them an invitation and a link to the webinar, just like you clicked on today. So anyway, we just thank you very much for your attendance, and we thank you for your business. Hope you have a great day, the rest of it.